Good morning, everyone, and welcome to the second in our series of webinars from DMH Stallard Property Team. For those of you who don't know me, my name's Emily Wood and I head up the Real Estate Disputes team here at DMH Stallard. As usual, the plan today is to look at some topical issues, some cases and some new law and policy in the world of both residential and commercial property. The lineup that we have this morning for you kicks off with Vanessa Joll discussing the latest on the government's consultation on residential leasehold reform. Next, I will be giving you a brief reminder of the main issues in exercising break notices in commercial leases, and also look at a recent case where it didn't go quite so well for the tenant. Jonathan Crook will then be next to delve into the world of service charges with a look at a recent case on the topic. And finally, we've got Katie Lamb, who will enlighten us on some of the recent changes and policy in the arena of planning. In terms of housekeeping, we expect the webinar to last about 50 minutes to 1 hour, and will allow for questions to all the speakers at the end of the talks. Please do use the Q&A function at the bottom of your screens to put in any questions whilst we give our talks, and then, as I say, we'll address them at the end. If we haven't got time for all questions, please rest assured that we will come back to you either with an email or pick up the phone to you to answer your question. If you have any technical issues or need to give any feedback or speak to our technical team, then please use the chat function that's also at the bottom of your screen. So let's get started, and to our first speaker, Vanessa.
Thanks, Emily. Morning, everybody. I'm going to kick off this morning by giving you an update on the progress the government's making in consultation on amendments to the law relating to ownership of residential leasehold property. I last spoke about this at a seminar we gave in early 2019, just after the government published its consultation on the issue. I think at that stage it's fair to say there was a reasonable amount of scepticism as to how much of a priority the government would make this issue. But in the last 2 years, I think it's also fair to say there's been significant progress towards reform and clarity as to what the new law will look like. Just to give you a bit of background in case this isn't an area that you've been following, this all started off because of a market trend that developed where developers of new properties were selling off leasehold interests, both in flats and houses, but I think the particular issue arose with houses, subject to very valuable ground rents, often escalating, doubling every X number of years. And they were then selling off the freehold interest in those properties separately as a valuable asset. The lending market responded to this by refusing to accept these leasehold interests subject to onerous ground rents as security for lending, which in turn led to these properties becoming unsaleable and unmortgageable, and caused a huge amount of financial hardship to individuals. That in turn, of course, met a lot of press coverage. The government published a white paper and entered into consultation with the industry on the issue. If you want to read any of that, it's on the slide. And then in early 2019, the Housing, Communities and Local Government Select Committee published its report on the issue, which was, to say the least, pretty damning. It concluded that key elements of the current leasehold system were open to abuse, and that the whole system was in need of a major overhaul. And interestingly, made a specific recommendation that it thought that going forwards, the primary model of ownership for flats in England and Wales should be common hold. So that led to the project becoming a much wider one than the original mis-selling scandal, which had started the government's interest in the issue. And the Law Commission was asked to review the current law and make recommendations for reform. Next slide, please. So in July last year, the Law Commission published 3 reports making a number of recommendations as to the reform of the law in this area. The key recommendations were the introduction of a simpler regime to make enfranchisement rights available to all leaseholders, both in extending their leases and buying out their freehold interest. They recommended the introduction of one uniform right for any leaseholder to extend the term of their lease by 990 years at a zero ground rent in return for a premium. And they also recommended the introduction of two rights aimed at tackling this issue of onerous ground rents. The first one was a cap on the level of ground rent which could be applied when assessing the premium payable on enfranchisement. And they suggested that if the government weren't interested in or weren't prepared to consider that they look at a right for a leaseholder to extend the term of their lease without buying out the ground rent element of it. And conversely, their second recommendation was that a leaseholder should have the right to buy out its ground rent without extending the term of the lease, thereby avoiding paying the reversionary element of the premium. It also made recommendations for wholesale reform of the rights of leaseholders to acquire their freehold interest, and they suggested a three-tier system. The first being a right for an individual leaseholder to acquire the freehold of his building where he was the only leaseholder in that building. The second being a collective right of freehold acquisition for a group of freeholders, a group of leaseholders who all had leases of property within one building. So that's similar to the right that currently exists. And the third was a right of leaseholders on an estate of multiple buildings to acquire the freehold interest in that whole estate. That would be a new and quite different right from anything that exists at the moment. They also made recommendations for a new and simplified procedure for making these claims. I think it's fair to say that the Law Commission recommendations went a lot further than most people expected and were met with quite a bit of scepticism as to how much of a priority the government would make them. Next slide, please. But then in January 2021, notwithstanding a global pandemic and Brexit, further progress was made. The Law Commission published its final report in the series, which looked at its recommendations for the reform of leasehold valuation mechanisms. And this was immediately followed by two government statements clarifying how they saw the Law Commission's recommendations and in which they proposed to adopt and when. The government statement started with a very clear focus on the fact that the primary and that their first priority was going to be the abolition of valuable ground rents, so that there would be new law introduced as soon as possible to make all new leases granted at a zero ground rent. And that is undoubtedly priority number one for them. The statement goes on to say that their second priority is around the reform of the valuation mechanism for leasehold enfranchisement. And I think the intention behind that is that essentially it has an immediate impact on tenants. It makes it cheaper for them to extend their leases or buy their freehold. The way in which the valuation mechanisms were to be reformed, the government said they were looking to abolish marriage value. What they mean by this is not that they abolish the concept altogether, but that the marriage value which attaches to a freehold interest by reason of a leasehold interest falling below 80 years would no longer form part of the compensation payable to a freeholder on enfranchisement, so making it much cheaper for leaseholders where their lease is shorter. The government also intends to introduce a cap on the quantum of the ground rent that could be capitalised on valuation on enfranchisement at 0.1% of the freehold value, thereby allowing leaseholders with onerous ground rents to enfranchise or extend their leases more cheaply. They plan to introduce prescribed rates of capitalisation and deferment on valuation. It doesn't say who's going to prescribe them, but it says that they will be at a market rate. And I think the intention is that by prescribing those rates, it will limit, if not remove, any arguments as to valuation on enfranchisement. The other thing that's interesting is that tenants will be able to agree to a voluntary restriction on development when they enfranchise, so as to avoid paying development value on the premium. And in the hope that all of that will create a much more prescribed system, the government then plans to introduce an online calculator so that tenants can see exactly how much it's going to cost them to extend their lease or buy their freehold at an early stage. Next slide, please. The other area the government statement covers is the reform of the procedure for lease extensions. As it is at the moment, owners of leasehold houses can extend their lease by 50 years plus the unexpired term at a modern ground rent, which is always open for debate. And the owner of a leasehold flat can extend their lease by 90 years plus the unexpired term at a zero ground rent. The government plans to replace this with a single right for both houses and flats to a new lease for a term of 990 years plus the unexpired term at a zero ground rent in return for a premium. In order to balance out the landlord's interests, there will also be a redevelopment break at the end of the existing term and every 90 years thereafter. The government statement also says that they plan to introduce a right for a leaseholder to buy out their ground rent without extending their lease. The statement doesn't address the other areas of recommendation in the Law Commission reports, but I think what it does make clear is that the government's committed to a much wider reform of this area of law. And one thing the statement goes on to say is that the government intends to promote common hold in place of the leasehold system for the ownership of flats going forwards. And it seems clear that over time the leasehold system will be phased out. With this in mind, the government is establishing a common hold council, which is a partnership of leasehold groups, industry and government, who it hopes will prepare homeowners and the market for the wider take-up of common hold in the future. Next slide, please. In terms of timing, the priority in the statement is clearly said to be the abolition of valuable ground rents, and it's intended that this will be implemented in the next session of Parliament, so become law probably in late 2021, early 2022. And this will, the government says, include the retirement sector, who lobbied hard to be exempted from these provisions, but will be included. I think there are probably some other provisions that will make their way into the first stage of the bill, but I think that the government's intention is that the remaining provisions, including the proposed changes to valuation, will be a second stage of legislation, probably happening towards the end of 2023, early 2024. Now, these are ambitious reforms which in the longer term will rewrite the law on enfranchisement, the right to manage, and we're likely to see common hold as the most common form of ownership for flats going forwards. Whilst it's not law yet, what is clear is that it's already affecting the way in which we advise leaseholders, particularly where they have shorter leases and they're likely to pay a large element of marriage value on the purchase of their freehold interest or their lease extension. I think the government's plans are clear enough now that where a leaseholder can wait, it may well be in their interest to do so. That's all from me on the subject, and I'm going to pass back to Emily.
Thanks, Vanessa, very much. So it's an infamous anniversary today, 1 year since the first lockdown was announced by the Prime Minister in the UK. And the unfortunate reality of the last 3 lockdowns is that we as property lawyers have seen an increase in instructions from our tenant clients to advise on options of bringing leases to an end of surplus property. In so doing, obviously, one of the options that we advise on is to look at the lease and to see if there's a possible break clause to exercise. So today I'm just going to give you a whistle-stop reminder of the main considerations when looking at these options to break a lease, and then mention a recent case which, as I say, the exercise of that break was held to be ineffectual by the court. So many leases usually over a certain length will include a break clause, basically an option to bring the lease to an end before the end of its term. Sometimes those breaks can be exercised by a landlord, and usually the most common reason for that is redevelopment. But most are tenant-only break clauses to be exercised by tenants to bring the lease to an end. Such breaks will usually allow any tenant to exercise the break, so not only the original tenant, but any assignees of the lease during the term. But that's not always the case, so you must look carefully at the wording. It is possible that the exercise of the break can only be done by the original tenant if the wording is clear on the lease. The types of breaks that you can have are obviously fixed breaks, so it will give you an exact date, which will be the break date, and you'll have to give so much notice before that break date in order to bring the lease to an end. Or a rolling break, so it may be after so many months of the term, the tenant can then exercise a break at any time, provided it gives sufficient notice. With either type of break, time will be of the essence. So if the clause requires 6 months notice to end the lease, say on the 12th of March 2021, then giving 5 months notice and 29 days just won't work. It will be insufficient. What we're going to look at more today, though, is the difference between unconditional and conditional breaks. So some obviously will attach a condition to the break, and some can just be exercised provided the notice is served. Next slide, please, Amber. So when looking at break conditions, the first thing is to consider is the condition attached to the break itself, or is it simply just something the tenant must separately do? The difference in the wording can be quite subtle. So if a clause says the lease can be broken on 6 months' notice provided the rent is paid up to date, then that's a break condition. And if there are arrears at the break date, the lease won't come to an end. But equally, a lease could say something like the lease can be broken on 6 months' notice and the tenant must pay its rent up to the break date. And that's unlikely to be held as a condition. So the lease can come to an end despite there being arrears of rent as at the break date. So again, it's a matter of looking carefully at the wording of the clause. If it is truly a conditional break, so the condition attached, such as the payment of rent, is necessary in order to bring the lease to an end, then that condition will be very strictly interpreted by the courts. The courts are very ungenerous to tenants when it comes to break notices. And if, say, for example, all rent must be paid in order for the lease to come to an end, even the smallest amount of arrears could scupper the break. Another trip hazard for tenants can be the timing of conditions. Again, the wording of the lease can be very subtly different. For instance, if the lease says that the tenant can serve a break notice if there are no arrears, then there must be no arrears at the time the notice is served, rather than at the time of the actual break date. So again, it's a matter of looking at the wording. As to what conditions to breaks we most commonly see, I've obviously mentioned the example of the payment of rent as a condition for a lease to be brought to an end. It may not only be rent, though. It may be worded wider to cover all payments, for example, under the lease. And then that might include insurance, rent, service charge, or even interest. Another common condition is some form of compliance with covenants. It might be compliance with all covenants, or it might specify the covenants which the tenant must have complied with in order for the lease to come to an end. The obligation can either be qualified or absolute. So if it's qualified, it might say that the tenant must have materially complied with its covenants. If it's absolute, it will say that it has to have complied with its covenants. Obviously, the former is much easier to comply with than the latter, and I would never advise for a tenant to agree for a break condition to be an absolute obligation to comply with all its covenants, which would be very hard to satisfy. What is sometimes agreed into break options is a condition that the tenant must return the premises with vacant possession. And it's this condition that the court recently looked at in the case I will discuss. Next slide, please. The term vacant possession as a condition is not as straightforward as it might appear, and it is sometimes misunderstood. Vacant possession is a legal term, And it doesn't just mean the tenant can hand back the keys and make sure that there are no people in the premises, for instance. The courts have had to battle with this term in many cases over the years as to what exactly it means. It's not the complete answer, but recent cases have come up with, as a starting point, the application of two tests. The first test being, is the tenant still using the property for their own purposes after the break date? And secondly, is there a substantial impediment to the landlord's use of the property or a substantial part of the property after the break date? And that may not be physical impediment, but it might be a legal obstacle to using the property. If the answer to either of these is yes, then there's a real risk that the tenant hasn't handed back the property with vacant possession. And if that's the condition to the break, that the lease won't end. It's easy to see, therefore, why a lot of the disputes before the courts as to whether vacant possession has been given concerns cases where the tenant has left items behind, fittings, goods, chattels, etc. Is the tenant still using the premises for storage, for instance, after the break date if it has left some of its goods behind? Or are these impeding the landlord's use of the property going forward? However, at the end of last year, we saw the opposite in a case that I want to look at. Next slide. Oh, sorry, not next slide. The case was Capital Park Leeds PLC versus Global Radio Service Limited. Here we had a lease dated 2002 for 24 years. The premises were being used as a broadcasting studio, but became surplus to requirements by the tenant. Break clause for the tenant was to terminate it on the 12th of November 2017, but it was conditional. It was conditional on the tenant giving vacant possession of the premises to the landlord on the break date. The lease defined the premises to include all fixtures and fittings, whether fixed to the premises, and all additions and improvements that have been made to the premises over the years, except for tenants' trade, fixtures and fittings. So fairly standard wording as to the definition of premises. The tenant exercised the break clause and then on the break date returned the keys to the landlord. However, prior to the break date, the tenant had started works at the premises and it had stripped out various features and fixtures, including the ceiling tiles, fire barriers, fan coil units, ventilation ductwork, floor finishes, windowsills, lighting, radiators, ceiling, etc., including cabling, and effectively left the premises as a shell. The landlord therefore brought a claim to court to say that the tenant had not successfully broken the lease because it hadn't returned the premises to the landlord with vacant possession. The tenant defended itself, saying that the condition in which the premises was returned was not a matter of vacant possession. It was simply a dilapidations claim that the parties could deal with after the lease had come to an end. The court went through the detail of correspondence and meetings that had taken place between the parties' surveyors prior to the break date, when they were looking at dilapidations liability of the tenant. The landlord had indeed served a schedule of dilapidations, and on receipt, the tenant had started works appointing a contractor, and they got as far as strip out. However, there was then clearly some uncertainty around M&E as to what formed part of the original premises and therefore what liability the tenant had to reinstate. The parties agreed sensibly to appoint an M&E consultant to report on what works needed to be done and the cost of those works. And whilst that report was being commissioned, the tenant halted all works to the property. Once the report was received, the tenant made a cash offer in settlement of dilapidations, but this was rejected by the landlord. By the time those negotiations had concluded unsuccessfully, there was then insufficient time for the tenant to undertake the reinstatement works of the M&E and other items, and no agreement was in place before the break date was reached. So the landlord went to court for a declaration that the lease continued beyond the November 2017 break date and had not in fact come to an end. The tenant claimed in court that the landlord had agreed that the tenant should not continue to reinstate the work and that the property could be returned in its strip-out state, and that the dilapidations were going to be settled by means of a financial basis. That argument failed. The court went carefully through all of the correspondence and meetings and concluded that there was no formal agreement for the works to stop at any stage agreed by the landlord. So the tenant then argued that the break was nonetheless satisfied because the concept of vacant possession, which was the condition that it had to meet, did not require any assessment of the physical condition of the property, nor any consideration of the tenant's repairing obligations. Instead, what was required by vacant possession was simply to ensure that the landlord gets back a property free of people, free of chattels, and free of any existing legal interest. This nice, simple approach was, however, rejected by the court. The judge concluded that when considering vacant possession, you do look at the physical condition of the property, and if there is a substantial impediment to the landlord using it after the break date, then vacant possession has not been given. What was telling, as far as the court were concerned here, was the M&E report that the parties had commissioned earlier clearly said that the deterioration in the condition of the M&E plant at the building could have led, for example, to business interruption for the landlord, non-compliance with legal requirements, health and safety problems, and a depreciation in the asset value. So the requirement for VP of the premises at the break date was to precisely ensure against these, so that the tenant handed back against the tenant handing back an empty shell of a building which was dysfunctional and unoccupiable by the landlord. As such, the tenant failed to comply with the vacant possession condition of the break, and the lease continued. The case is fairly specific on its terms. However, it is being appealed, and we'll be watching this space to see what the outcome of that appeal is. So that's all from me. As I say, if you have any questions, please do use the Q&A function and we'll address them at the end. And now I'll hand over to Jonathan to look at service charges.
Good morning, everybody. For those that don't know me, I'm a partner in the commercial property team at DMH Stallard. I am going to talk to you today about service charge in commercial leases. I'm going to give you a brief reminder of the basics of service charge, and I'm going to run through a recent case, which is of interest in relation to leases. So the basics first, and many of you watching, agents who do heads of terms, will be very used to some of the points that I'm going to talk about, which are very important in many leases. So we're almost always talking about a lease of part of a building where the landlord retains the structure of the property, so it's a non-structural demise. So to give some examples, a unit in a shopping mall, an office suite on one floor of a building, or, and this one is slightly less obvious, a ground floor shop with flats above it. In that case, you might perhaps not call it service charge, but the principle is much the same. So what we're talking about is where the landlord is carrying out repairs to the building, for example, to the structure or the exterior of the building, and the tenant is going to pay a proportion of the cost that the landlord incurs. How are those costs paid? Well, if you've got let's say a shopping mall, the usual way would be on account service charge payments, let's say on a quarterly basis, and then there'd be a reconciliation at the end of the service charge year. The landlord would add up what has been spent and what the tenant has paid and work out whether more or less is due. And in fact, I've said here, how do you do with overpayments and underpayments? So if the tenant has paid too much, what the landlord usually does it holds on to that overpayment and then sets it against the next payment the tenant has to pay under the lease. The landlord doesn't want to be paying it back for a month or so. If the tenant's paid too little, then the landlord, surprise, surprise, will want that money pretty quickly. And so usually the tenant has to pay an underpayment within, let's say, 10 working days of the certificate being issued. There are other ways to deal with service charge costs. Another option, and this is more likely perhaps where you have a shop with flats above it, is that the landlord simply charges the costs as and when they're incurred. So in years when there's nothing to do, there won't be a service charge. But in a year when the roof is being repaired, then there will be a service charge, and you just charge them as and when you incur them. Next slide, please. Now, a crucial point to remember for commercial leases is that there is no legislative protection for tenants. For those of you who are used to residential leases, this might seem a bit odd, but that is the way it works. There's no legislative protection, so the tenant is stuck with the drafting of the lease to obtain its protection. So that drafting that we work on and the surveyors work on is very important. So first, just to think about two important questions. Which services is the landlord required to provide? When you get a draft lease, the landlord solicitors issue it, and usually it's not a very long list of services the landlord is required to provide. As a tenant, you need to think, what are the services that I cannot do without? So if you're in an office lease, the obvious ones, first few would be you've got to maintain the structure, you've got to keep the lift working, the common parts have to be in order, that sort of thing. So you've got to make sure in that compulsory list is everything you might want. There is then usually a much longer list that the landlord puts in where if it chooses to provide those extra services, it can recover the cost. It's very important to see the distinction between those the landlord is required to provide and those it may provide. And as I say, the list of those it may provide is usually very long, and it usually ends up with a sweeper saying anything else the landlord reasonably provides in the interest of good estate management, something like that. So what protections does the tenant have? Well, one protection that the agents will deal with lots of times is a service charge cap. So this is a way where the tenant will say, yes, I have to pay a service charge, but I know it will not be more than a certain sum per year. That then allows the tenant to set its finances, know how much it's going to pay without having large sums suddenly. Should that cap go up, if you've got a 10-year lease or even a 5-year lease maybe, would you want the service charge cap to go up as the landlord? Fairly frequently, you would see a cap being increased by reference to indexation, often RPI, but sometimes CPI. What happens if you don't use the cap in 1 year? I've come across this recently. Let's say you've got a cap of £100, and in the first year, the service charge is £20. Should that £80 be able to be moved forward to another year for the landlord's benefit? That's worth thinking about. What other protections does the tenant have? Well, there's yet another list of services you often find in leases, especially these days, which is a list of excluded costs. So those will be costs that the landlord can't recover through the service charge. Many of these will be ones that you'd say, well, why would they try and recover that? But it's just to protect the tenant. So the sort of thing you're talking about is costs the landlord incurs in recovering rent from a defaulting tenant, costs the landlord incurs in granting other leases or dealing with consents, ones which really aren't they don't benefit the tenant in our lease. So you'd like to exclude those costs from the service charge. Those are coming in more and more these days, partly because the new practical law precedent leases do now have an example of having excluded costs. So you'll tend to see those more. And then an obvious way to protect the tenant is, if you can get it, try and limit costs by way of reasonableness or possibly proper. Those can certainly help. It can still lead to arguments, but if it just says the costs, then it's much harder for the tenant to argue they're too high. I'm now going to come on to certificates and the case I'm going to talk about. Often leases will say that the certificate the landlord issues at the end of the service charge year is conclusive and can't be challenged by the tenant. That was what happened in this case. Next slide, please. So I'm going to talk about this case. It's a case, the Court of Appeal decision was last year, 2020, Sara and Hossain Asset Holdings Limited. It was against Black Outdoor Retail Limited. We were talking about retail premises in Liverpool. So in the lease, I think there were two actually, the landlord had, in a fairly standard way, to calculate the total cost of the services and expenses. There was also a list of excluded costs. The landlord then, at the end of the service charge year, had to give a certificate as to the amount of the total cost it had incurred first, and also the sum the tenant had to pay. So there'd be a proportion the tenant had to pay, and that would be its service charge. The lease said the certificate was going to be conclusive in the absence of manifest or mathematical error or fraud. So the sort of thing you're getting at there is, if the percentage is supposed to be 10% and the landlord makes it 50% by mistake, you should be able to challenge that, but it gives you less scope otherwise to challenge the certificate. What happened here was the landlord certified a large sum in 2017, 2018, larger than in previous years, quite considerably larger, and claimed the unpaid service charge from the tenant. The tenant didn't pay, and the landlord claimed that service charge. Sorry, the landlord went to court to try and claim that service charge. So at first instance, the court said that the natural construction of the lease was that the landlord's certificate was conclusive as to how much the landlord had incurred, but not on the separate sum as to whether all those costs fell within the service charge that the landlord could charge. The court said there was an important distinction. So the court held for the tenant. The landlord appealed to the Court of Appeal. Next slide, please. So Court of Appeal at the end of last year, the Court of Appeal reversed the decision. The court said that the judge at first instance had erred in holding that the tenant was correct. The lease said that the landlord's certificate on the service charge was conclusive as to the amount of the total cost. The lease didn't distinguish between the type of costs that could fall within the service charge and the actual amount of those costs. The lease did not distinguish between those at all. The Court of Appeal therefore felt that the certificate was conclusive as regards the single figure of the total cost that involved both elements I've just mentioned, i.e. whether they could fall within the service charge, and if they did, what the cost was. Both of those were covered by the certificate, and the certificate was therefore conclusive. There were no words in the lease saying that this wasn't correct, and the court didn't see any reason to imply extra words to say that. The court felt that the judge at first instance had been swayed by the fact that this interpretation would mean that the landlord would effectively decide its own certificate. Well, that's the case, but the Court of Appeal said that's what the lease said. Next slide, please. And the court went on to say, well, yes, that is it. The landlord does effectively have the right to decide, and they went on to say a tenant would be well advised to consider very carefully before they should enter into a lease in this form. However, following on from recent cases, the court said it wasn't for the court to save a party from an imprudent and unwise term. If the party had decided to enter into that lease, the court would give effect to it. It wasn't for the court to rewrite the lease to make it fairer. And that stems from a Supreme Court case a few years ago. The clause made sense for the landlord, certainly. It would avoid arguments for the landlord about how much the service charge would be, save the landlord management time, and make life much easier for the landlord. The court said that the fact that elsewhere in the schedule there was provision for an expert to determine disputes, that was in respect of the tenant's proportion, didn't affect the decision on other points. So the landlord won. The certificate was conclusive both as to the amount the landlord had spent and as to whether it actually fell within the scope of the service charge as defined by the lease. So a relief for the landlord, very disappointing for the tenant. And it's worth bearing in mind that this is a pretty standard clause in commercial leases. So it's worth watching out for this. If as a tenant you want to have more flexibility and be able to challenge that certificate, based on this case, you're going to need to amend that wording in the lease to make it clear that you can challenge some part of that certificate. So watch out for that wording. As I say, it's not unusual. And just bear in mind that no legislative protection, it's down to the lease what protection each tenant has on service charge in commercial leases. It's not quite the end of the story, because I understand the tenant is now seeking permission to appeal to the Supreme Court. So we'll have to wait and see whether that is allowed and whether the Supreme Court then do make the same decision. If you have any questions, do ask them on the question and answer function on your screen. Otherwise, thank you for listening to me, and I'm going to pass over to Katie, who's going to give a planning update.
Thank you very much, Jonathan. So I'm just going to spend a few minutes talking you through some of the most significant new planning policies and legislation in 2021, ultimately all guiding new development towards a higher environmental quality. Next slide, please. So starting with the Environment Bill and Biodiversity Net Gain and how this may influence your developments coming forward. The Environment Bill was first tabled in January 2020 and has since been through committee stage and is partway through its third reading in the House of Commons, having been delayed by the COVID pandemic. It is just one part of the government's drive for zero carbon emissions by 2050. The bill is intended to set out a range of measures to protect the natural environment, tackling biodiversity loss, climate change, and environmental risk to public health. It includes obligations on councils to produce spatial nature recovery strategies, local habitat maps, and legally binding targets to reduce fine particulate matter and reduce air pollution. Most significantly, however, it includes an obligation on developers to deliver biodiversity net gain of 10% from the baseline on all new development. This will be through on-site biodiversity enhancement or through habitat compensation at a strategic level through a credit or tariff-based system, or a combination of both. For some sites, such as agricultural or previously developed land, 10% net gain may be easily achievable on site. However, for vacant meadow greenfield land, which has not been maintained, and may therefore have a high biodiversity baseline, it might be more difficult to achieve on site and may significantly reduce the developable area. Until councils have identified strategic sites for habitat creation, there may be some delay to the use of an off-site credit-based payment system. Additionally, although there'll be a lead-in period, some local authorities are already requiring biodiversity net gain, either through interim policy or through pressures of planning committees. It's therefore important that you consider at the earliest opportunity how this might impact the capacity of your site to accommodate development. As part of the Environment Bill, the government will also bring forward an Office for Environmental Protection, which will be launched on an interim and non-statutory basis in July this year. And this office will provide an independent oversight of the government's environmental progress. Next slide, please. As part of a drive for higher quality development, and as first suggested in the government's white paper, the government are currently consulting on changes to the National Planning Policy Framework, or NPPF, which will enshrine beauty and placemaking in the planning system. And it follows that any development which is not well designed should be refused. As part of the beautification of development, there's a heavy emphasis on trees, including tree-lined avenues and other measures that incorporate trees within proposals, such as community orchards. And both of these could enhance your on-site biodiversity net gain. The changes will mandate councils to create local design codes, which are supported by a national model design code, which is also currently out for consultation. These design codes will be visual and numerical and not detailed planning policy, and they should be measurable. The hope is that at some point, computer programs may be able to read design codes to help and streamline the planning system. Additionally, a national design guide has been published and sets out 10 characteristics of well-designed places. These include context, identity, built form, movement, nature, public open space, uses, homes and buildings, resources and lifespan. And the government has pledged an Office for Place to support local communities and councils with the implementation of these measures. Next slide, please. Now, although not strictly planning, the government are also committed to improved building sustainability and hope to publish a future home standard by 2025. These measures will be incorporated into building regulations. The technical specifications will be consulted on in 2023 and legislated for in 2024, but ultimately requiring 75% less carbon emissions from new development. Interim measures will be brought forward towards the end of 2021, and this will require all new homes to produce 31% less carbon emissions through the building fabric, low carbon heating and the use of PV panels, all domestic buildings will be required to produce 27% less carbon emissions. Now, whilst these measures sit outside of planning applications for new development should be prepared with these in mind. Many applications brought forward in the short term may not be built out until these measures are in place, and as such they should be designed to reflect the new requirements. For example, as part of the Future Home Standards, the use of gas boilers in new development will be banned, and development should be considering the heating alternatives now during the application process, as this may have a direct impact on design and cost. Additionally, the future introduction of these measures is not lost on planning committee members who are already pushing for these higher levels of sustainability and energy efficiency through interim policy or broad policies for energy efficiency. And some developers are already committing to these high standards, which raises the bar considerably. Next slide, please. So what other changes can we look forward to this year? Well, the headline arising from the 2020 white paper is the introduction of zonal planning, which would be a major shake-up in the current planning system. It is expected that this will become legislation, and later this year, with reference possibly being made in the Queen's speech in May. This would see land split into three categories: growth, renewal and protection. Growth areas will be categorised as suitable for substantial development, with permission granted automatically to developments that meet all other policy requirements. Renewal areas will include those that are suitable for some redevelopment, and protected areas will be places where development is restricted, such as on landscape or ecology grounds. There will be more permitted development rights, with a new commercial business to residential PD right, to tidy up changes in the use class order and the introduction of use class E, and a faster approval route for public service buildings such as hospitals and schools. There may also be a new model for shared ownership housing, which will reduce initial shares from 25% to 10%. Gradual staircasing will be allowed from 1% rather than 10%, and more control to owners over the future sale of their homes. The proposed amendments to the NPPF also seek to limit the use of Article 4 directions to restrict permitted development, requiring them only to be used where they're absolutely essential for the purposes of protecting amenity, and where they are used to limit PD rights to residential, only where it is in the interest of national significance. They should also be of the smallest geographical area necessary. And lastly, on the 6th of April this year, national space standards for new residential development will be expanded to cover all new dwellings delivered through office to residential development, which will ensure that such proposals deliver satisfactory living conditions for future occupiers. I think we can agree that 2021 will bring many changes to the planning system, and subject to there being proper notice, guidance and policy for its delivery, we can all work within the new system to deliver more sustainable and quality environments in which we can live and work. Now, should a new system of zonal planning come forward, there'll be an interim period where we will all need to educate ourselves in the new system, which done properly will serve to streamline the planning process. Thank you for listening, and I'll now hand back to Emily, who's going to lead the Q&A session.
Thank you, Katie. We've had a number of questions in. We may not have time, just conscious of what the time is, to answer them all, so I will randomly pick one for each speaker. But please rest assured we'll come back to you on the other questions that we don't get a chance to cover either by email or giving you a call. So if I could start with Vanessa, question for you. Would Vanessa advise a leaseholder with a flat lease having, say, 85 years unexpired to wait for the legislation to be enacted before applying for a lease extension, or go ahead under the existing legislation?
Oh, that's a tricky one. I think there's a number of things to factor in there. The first one is obviously 85 years, you said, didn't you? So 85 years, you wouldn't pay marriage value anyway, so the abolition of that part of the compensation wouldn't benefit the leaseholder. May depend what the ground rent is. If the ground rent is particularly high and likely to create a big premium on buyout, then perhaps that would be a reason to wait. But otherwise, I think I would probably say, subject to valuation advice, that it sounds like it would be better to go ahead. because obviously you'd only get your 90-year extension, but you pay your premium for that, and that would reduce the premium that you would pay, I presume. Scarily getting into valuation advice here, and I've got this feeling there are lots of valuers out there screaming at the screen, but I think that probably what would happen is that then it would be cheaper to extend again and get the benefit of the 990 years once the new legislation comes in. So I think unless there's an onerous ground rent, my gut feel is that probably you would go ahead under the current legislation, subject to valuation advice. Okay,
brilliant, thank you. Jonathan, if I could address one to you, please. So it's on service charges, obviously. A tenant paying for electricity based upon the size of a unit within a building. Tenant starts charging an electric vehicle within its own demised parking space by simply connecting a cable through a window. Seems to be a breach of service charge provisions, certainly the spirit of the agreement. What do you think, Jonathan?
Well, it may be an interesting interrelationship between two parts of the lease there. It'll always depend what the lease says. A lease will almost always provide that a tenant pays all utility payments for their premises. So it may be you would cover it by that. The service charge is a separate part. And one thing that occurs to me is it may depend, for example, on how the proportion is determined. So if you've got a fixed proportion, it may be more tricky. But if, as you very often find in a lease, it says a fair proportion to be determined by the landlord acting reasonably, you could use that fair proportion in respect of perhaps a particular cost to cover what that tenant should pay. So I think it's going to be a mixture between working out whether it's caught by the utility clause and also looking at the service charge and seeing if there's scope to change the proportion in respect of different service charge costs.
Okay, thank you, Jonathan. Katie, one for you, if I may. How can local authorities justify the requirement for biodiversity net gain in the absence of any kind of legislation?
Thank you, Emily. There's many ways in which they can do it. They know it's coming forward, and obviously sustainability is high on the agenda. There are councils already bringing forward interim policies. Chichester, for example, have an interim policy for housing, which sets the bar very high, including biodiversity. And Wealdon has a policy already for net gain. So although they're not requiring 10%, they do require a net gain. There's, of course, general measures that are in policy for biodiversity net gain. And as developers are already offering these through development proposals, it's not lost on committee members. So anything that you can do to provide extra will obviously ease you through the planning process.
Okay, thanks, Katie. And only to be fair, I better address one to myself as well that we've had in. So how can a tenant then tie down a landlord to accept a cash settlement as satisfaction of a break condition such as vacant possession? Well, as often leases will provide that a landlord can waive any condition to the break. It usually has to be in writing and it should be very formally done. I don't think an exchange of emails would be sufficient. It should be done formally, as I say, in writing, to be able to waive a condition altogether. Otherwise, if you do reach an agreement, say on a cash settlement for dilapidations, that can include a surrender. So rather than relying on the break itself, you agree that the lease comes to an end via a surrender upon payment of that cash settlement. So there are ways of doing it. They didn't successfully manage that in the case that I referred to, but that's not to say it can't be done. Okay, well, that was one each. As I say, there are some other questions. We will come back to you directly, but I'm conscious of the time. And so thank you very much for joining us this morning. Really appreciate that. Slides and a recording of the talks will be available on our website shortly following the end of this seminar. Our next property seminar will be in May. We're always open to ideas of topics that you would like us to cover, anything that you're interested in or would like to hear more about. So please do let us know. And you can either email me or any one of the team with those ideas. But other than that, if we don't see you beforehand, we'll see you in May. Thanks very much. Bye-bye.